Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. So far in this contract law series, we focused on how contracts are formed. We've looked at agreement, intention, consideration, parties, and capacity. But now it's time to ask a different question. Suppose we know a valid contract exists. What exactly does that contract contain? Or to put it another way, what did the parties actually agree to? Because if a dispute arises later, that's one of the first questions a lawyer will ask. Who promised what? Which terms are binding? And if one of those promises is broken, what remedies are available? And that's what today's video is all about. So let's start by looking at the big question. When analysing contractual terms, there are really two stages. Firstly, what are the terms of the contract? And secondly, how important are those terms? The first question tells us whether a promise forms part of the contract. The second tells us what happens if that promise is broken. Let's take them one at a time. So the easiest place to start is with express terms. These are the terms that parties have specifically agreed. For example, you walk into a shop and you want to buy a television. The television, the price, the delivery arrangements, those are all express terms. There's no great mystery there. But in real life, contracts rarely consist only of the obvious promises. Instead, they often contain pages of additional conditions packed into the small print, and that creates the first challenge. So, how do terms get into a contract? Well, for a term to be enforceable, it must first become part of the contract. And lawyers refer to this as incorporation. For SQE purposes, there are three main ways terms become incorporated. Firstly, incorporation by signature. And this one is relatively straightforward. If you sign a contractual document, you will generally be bound by its terms. Even if you never read them, even if you don't understand them, even if they're hidden in several pages of small print, the law generally assumes that signing means agreement. Now, are there any exceptions to this? Well, there are a few. The main ones are where the term is illegible, the term has been misrepresented, or the term is particularly unusual or onerous and has not been properly highlighted. But these situations are all relatively uncommon. The general rule remains if you sign it, you're bound by it. The second method of incorporation is incorporation by notice, often known as reasonable notice. This usually applies when nobody signs anything. So think about tickets, notices, car parks, online terms and conditions. The key question becomes, was reasonable notice of the term given? Now, what factors matter? Well, the courts typically look at timing. The notice must be given before or when the contract is made, not afterwards. A term hidden in an invoice arriving later is usually too late to be a term of the contract. Visibility. Can the term actually be read? Tiny, illegible print is unlikely to help. Onerous clauses, the more unusual or burdensome the clause, the more a party must do to draw attention to it. And the courts expect important restrictions to be clearly highlighted. The third method is what's known as incorporation through previous dealings. So suppose two businesses have contracted with each other repeatedly over many years, always on the same terms, always using the same documents. Eventually, the courts may presume that both parties know those terms. And in those circumstances, the terms may become part of the contract, even if they weren't specifically discussed on that occasion. Let's turn to our SQE exam focus. So whenever you see a term hidden in the small print, ask, did this term actually become part of the contract? If it wasn't properly incorporated, the argument ends there. The term cannot be enforced. When we then move to a second point, suppose we've established that a particular term is part of the contract, the next question becomes, how important is it? Because not every term is treated equally. Some are fundamental, others are relatively minor, and that distinction affects remedies. Let's have a chat about conditions. So conditions are important terms, the sort of terms that go to the heart of the bargain. If a condition is breached, the innocent party may claim damages and terminate the contract. In other words, they can walk away from the deal. At the other end of the spectrum are warranties. These are less important terms. If a warranty is breached, the innocent party can claim damages, but cannot terminate the contract. The contract itself continues. Now, why does this matter? Well, because the availability of termination can be hugely significant. Sometimes the right to walk away from a contract is worth far more than monetary compensation. So correctly classifying terms becomes extremely important. The problem is that life isn't always neat. Some terms don't fit comfortably into either category. Sometimes a term might be breached in a minor way. Other times, exactly the same type of term might be breached in a devastating way, and that leads to a third category called innominate terms. These are terms that the courts take a much more practical approach with. Instead of classifying the term in advance, they ask, what was the effect of the breach? And the key question becomes, has the breach deprived the innocent party of substantially the whole benefit of the contract? If yes, termination may be available. If no, damages will usually be the suitable remedy. So the remedy depends on the seriousness of the consequences rather than the label attached to the term. Now let's move beyond what the parties specifically agreed, because contracts often contain promises that nobody actually says out loud, and these are known as implied terms. Now, why do we imply terms into a contract? Well, the answer is simple. Contracts would often be unworkable without them. Imagine again buying a new television. You don't specifically ask, will it actually work? You assume it will. And the law makes the same assumption. Certain terms are therefore implied automatically. Sometimes a term is implied because it reflects a well-established custom within a particular trade. The law recognizes that people operating in that industry may assume certain practices apply. Terms can often be implied in fact. So a term is implied because it's necessary to make a contract work. The traditional phrase is that it is so obvious it goes without saying. The parties never express the term, yet everyone assumes it exists. Well, sometimes the law implies terms because they are considered essential to a particular type of relationship. Employment contracts provide a very good example. Certain obligations arise simply because of the nature of the relationship itself. We also have terms implied by statute, and for SQE purposes, this is the most important category. Parliament has implied numerous terms into contracts involving goods, services, consumers, and businesses. These implied terms often relate to issues such as satisfactory quality, fitness for purpose, correspondence with description, and reasonable care and skill. The practical effect of these is that these statutory rights are incredibly powerful because they often create protection whether or not the parties expressly agreed to the term. The law effectively says these protections exist whether you thought about them or not. Now, what's Bowdie's bottom line? Well, every contents question starts with two issues. What are the terms of the contract, and what happens if one of them is broken? Start with the express terms. Ask if they were properly incorporated through signature, notice, or previous dealings. Then look for implied terms arriving through custom, necessity, law, or statute. Finally, ask how important the term is. If it's a condition, termination may be available. If it's a warranty, damages will normally be the only remedy. If it's an innominate term, everything depends on the seriousness of the breach. And remember, most contract disputes are really disputes about terms and remedies. Work out what the contract contains and you'll usually be halfway to solving the problem. Thank you for watching this episode of Bowdie Shorts. There are further videos available in the series now. Please feel free to watch any others from the playlist. Thanks again.